Today I will be discussing a brief introduction about the Indian Contract Act. Now, Indian Contract Act is considered as a relatively easy subject by the judiciary aspirants, but they don't realize the fact that when you're appearing for the examination, it might become a little confusing to memorize the provisions, the sections of the Indian Contract Act. Hence, I hope today's lecture will be an aid in that direction. Now, when you talk about the Indian Contract Act 1872, you will find that it has divided into 11 chapters consisting of total 266 sections, out of which 2 chapters have been deleted. Chapter 7, that is section 76 to section 123, and chapter 11 itself, that is section number 239 to 266. So, effectively speaking, Indian Contract Act ranges somewhere between section 1 to 75. And thereafter between 124 to 238, right? Now, in fact, it is these 2 divisions that can be divided into 2 parts of the Indian Contract Act. Section 1 to 75 is talking about the general principles of Indian Contract Act, whereas sections 124 to 238 is discussing the special contracts. Special because they are either establishing themselves as an exception to the general principles in some format, or they're expanding the applicability of the general principles. So, for this particular lecture, I will be restricting myself to the general principles of a valid contract, affecting a valid contract. And these general principles affecting a valid contract have been provided under section 1 to 75 of the Indian Contract Act, right? Now, when you talk about a contract as such, what is a contract? A contract is an agreement that is enforceable by law, as has been defined under section 2H of the Indian Contract Act. So this entire definition in itself has 3 variables: agreement, then enforceability by law. And it is these 2 aspects which are giving rise to the entire scheme of the Indian Contract Act between section 1 to section 75, right? So you will see, when you make a contract, what are the various stages that are there in a contract? सबसे पहले you will be formulating a contract will be formed. Then whatever are the obligations under the contract, those obligations will be discharged under the Indian Contract Act. And the last and the third part to that will be remedies in the case where the obligations have failed to be discharged, right? Now when you look at the scheme of Indian Contract Act, it is going to consist all these 3 stages. It is going to consider the cover the general principles with regard to all these 3 stages, right? So now let's talk about the first stage, that is the formation of the contract. Going back to the first statement that I made, contract is an agreement that is enforceable by law. So it's an agreement, and that agreement has to be enforceable by law. What is an agreement? Colloquially speaking, an agreement is nothing but consensus. You say something, I accept it, we both have reached on a common platform, there is consensus addendum between the 2 of us, so we are in agreement with one another with regard to certain specific facts and circumstances. This is the legal aspect of agreement as well. There is one person who is making a statement in the nature of an offer where he expects the other party to do something, and in lieu of that action by the other party, the maker of the statement is also promising to give something in return, quid pro quo. This is an agreement the moment the other party is accepting this. So I make a statement whereby I propose that you do something, and in lieu of you doing this particular action, I will do something else. When you accept this particular statement, both of us are on agreement with the facts that are involved in the statement, hence an agreement has come into being. So agreement, if you look at section 2E, which defines agreement, it states agreement is a reciprocal promise or a set of reciprocal promises forming consideration for one another. So what is happening over here? My promise and your promise is a set of promises, and it is forming a consideration for both of us. So when you talk about agreement, the starting point of the contract will be proposal or offer by one party, which will be accepted by the other party. They will promise to each other that they shall do something, and these promises shall form the consideration for each other's promise, thereby giving rise to an agreement. So one variable is sorted. Second variable is enforceability by law. Now when you use the word law over here, this term law is not restricted to only Indian Contract Act. Rather, it encompasses any law which is in existence in India, which is governing the validity of a contract. So what I mean to say is, when you're looking at the enforceability of a contract, it has to undergo two verification steps. First verification step is that it has to be valid under the Indian Contract Act. All the principles that are required under Indian Contract Act. And where are those principles given? The Bible of this particular aspect, the main provision of this particular aspect will be section 10 of the Indian Contract Act, which lays down that when does an agreement become a contract. So it has to fulfill the criteria that is laid down under section 10 of the Indian Contract Act. This is one aspect. Once it has covered this, once this platform is sorted, it goes on to the next touchstone, next criteria, which is whether it is valid under any other law for the time being, whether it is not violative of any other law for the time being. For example, I intend to sell my land to you for rupees 1 crore. Now in this particular case, I promise to you that I will sell my land to you provided you give me rupees 1 crore, which is going to be the promise on your part. Now both of us are majors, both of us are competent to enter into a contract. There is a valid consideration in the form of land and money between the two of us. It is my offer, it is your acceptance, to which you have accepted freely without any kind of pressure whatsoever in any nature. So under section 10 of the Indian Contract Act, the parties should be capacitated to enter into a contract, which the two of us are. They should enter into a contract with the free consent, that is, there should be no coercion, no undue influence, no fraud, no misrepresentation and no mistake on part of the parties for the contract to be valid, which is there in this case also. Thirdly, there should be a valid lawful object and consideration, which is in the nature of the buying and sale of the land. Hence, in this particular aspect, these aspects of section 10 are fulfilled. Then what is this remaining portion of law that I am talking about? Now, Transfer of Property Act, read with the Registration Act, requires that sale of property above rupees 100 has to be duly written and registered under the Indian Registration Act. We have complied with all the other requirements of this particular agreement, but where we failed is, we failed to get this particular transaction between the two of us registered under the Indian Registration Act. Done? Now, I am ready and willing to sell you the land, but you are not ready and willing to give me the money as has been decided between the two of us. What has happened over here? You have breached the supposed contract. What is the remedy for me? I will go running to the court. I will say to the court, ask that person to give me the money. I want to enter into this contract. I want to make sure that I get the money. I want to sell my land to this particular person. The court will look at the contract. The court will say, fine, section 10 is complied with. But what have you not done? You have failed to comply with the other law of the land, which requires the registration of the contract. Hence, this contract is not going to be admissible and enforceable in the code of law. Therefore, when you talk about the validity of a contract, when you talk about when does an agreement become a contract, it has to be between the capacitated parties who are entering into it with the free consent for a lawful consideration, for a lawful object, and it should be valid under the Indian Contract Act as well as any other law which is stipulating any other requirements for a valid contract. This is the entire pro forma that you will find under section 10. Right? So when you look, now let's look at the scheme of the Indian Contract Act. Section 2, I told you, is talking about the definitions from where we have borrowed all this as of now. Section 3 to section 9 is going to talk about the offer and acceptance. I made an offer to you, you accepted, only then did we come to an agreement. So how is the offer communicated? How will you make the acceptance? Whether the offer that I have made to you is permanent or can I revoke it? All these things, the entire aspect of agreement has been covered between section 3 to section 9. Then section 10 lays down the criteria of a valid contract. And from section 11 onwards till section 36, you are going to talk about these criteria that are there. For example, if you will look at the scheme now, section 11 and 12 is going to talk about capacity, which we have referred. Section 13 to 22 is going to talk about free consent and consent. Section 23 to section 30 is going to talk about lawful consideration. What amounts to lawful consideration? Whether the consideration can be lawful or unlawful in part. What are the various forms of lawful consideration or unlawful consideration that have been so regarded by the Indian Contract Act. Hence, section 23 to 30 is in some form or the other talking about the consideration. Right? Section 37, 31 to 36 is contingent contract. It is a type of contract, so you can leave it apart for now. Section 37 to section 67 is now talking about the performance of contract. So going back to the first statement that I made with regard to the stages of contract, you saw there was formation of contract, then there was execution of contract, and finally there is discharge of contract or breach of contract, remedies for the breach of contract. So now section 37 to section 67 is going to talk about the second stage of this particular contract, that is your breach of contract, your rescission of contract, novation of contract, etc., and your performance of contract. Right? For example, under section 62 and 63, it is talking about rescission of contract. Section 56 is talking about discharge of contract by frustration. Section 39 is talking about breach of contract. The remaining provisions are talking about when will the contract be performed, by whom will the contract be performed, what happens when time is the essence of performance of contract, section 55. All in all, section 37 to section 67 will talk about the various modes that the contract can come to an end or be discharged. So it can be discharged by rescission, it can be discharged by novation, it can be discharged by breach, it can be discharged by performance, and finally it can be discharged by frustration, that is external circumstances which leaves the party remedialess in certain circumstances. This is the second segment of the formation of the development of a contract. Clear? Now the third and the last segment that you talk about, which was the remedy in case the contract has been breached. This particular segment has been discussed between section 73 to 75 of the Indian Contract Act. So till 67 you are already clear. From 37 to 67 we were discussing about the discharge of contract. From 73 to 75 we are discussing about the remedies with regard to breach of contract. Now in between these two segments there is something that is 68 to 72 which you call as legal obligations similar to the nature of contracts, in other words quasi-contracts. Now these are not contracts, these are certain legal relationships which create certain obligations on the parties which may be similar to contract and exist in cases where there can be no contract between the parties whatsoever. Full stop. So let's leave this for now. Third stage was supposed to be the remedies in the case of breach of contract. Sections 73, 74 and 75 talk about these remedies in the nature of liquidated damages, unliquidated damages, and finally the remedy with the party where it is rescinding the contract lawfully. Section 75 becomes applicable wherever there is a rescission of contract by the party under section 39, 56, 54 and 55. So this, if you will understand, is the entire holistic scheme. If you are aware of the stages of the contract, you will also be aware, you will also be able to understand that the Bayer Act is proceeding in the same manner. The first part is talking about agreement. When you will look at section 3 to 9, how does an agreement come to being? The second part is talking about the execution, discharge of contract, and the last part is talking about the remedies of the contract. Thank you so much.